rises. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah.
All right, welcome back. Welcome back to part 3. We are here to get into Armon Wiggins versus the NOT. Now, the particular court document that I will be showing in part 3 is the anti-SLAPP statute that the NOT filed in rebuttal of Armon's original petition for restraining order. Now, before we actually get started, let me make sure y'all see my copyright disclaimer on the section 107, just simply saying that, hey, this is fair use. I am not a paralegal, I am not an attorney, and I am also not a judge. I am simply saying that, hey, I have common sense and I know how to read. Also, top left-hand corner of your screen is my QR code. That is the direct link to my X page where you will see it there first. You can get into a plethora of other court cases, get the discussion popping, or however you see fit. Now, without further ado, here is the actual document. Now, I will say, on the particular website, this particular court document is still unavailable. Now, I'm not sure how the NOT found me, but I'm pretty sure, with a lot of traffic coming through my X page, I tend to do pop up in people's mentions. And so maybe he saw me in his mentions and I started to cover the case on X and he chimed in and asked me and let me know, hey, I also filed this. And I was like, well, it's not available. I tried to pull it the night before. It's not available. And so he sent it to me. So this is the document right here. This is notice in motion of defendant Denot Ricketts, special motion to strike 425.16, which is the anti-SLAPP statute. Memorandum of points and authorities, declaration of Denot Ricketts in support thereof. And as y'all can see there, it does say judge is to be determined. Okay. Now, please take notice that on January the 23rd of 2026 at the Metropolitan Courthouse and address listed above, defendant Ricketts moves this honorable court with a motion to strike plaintiff civil harassment prevention pursuant to California Civil Code of Procedure 425.16, which is the anti-SLAPP statute. This motion is made on grounds that the request for restraining orders improperly challenges protected activity under the First Amendment. This motion is based on this notice of motion in motion, accompanying memorandum of points and authorities, plaintiff's request for restraining orders, the pleadings and papers filed in this action, and such further argument in matters as may be offered at the time of the hearing on this motion. As y'all see, this was done on December the 8th of this year, 2025. Okay, so let's get into the memorandum of points. So introduction. Plaintiff Armon Wiggins requests for permanent restraining orders, or also known as PRO, against defendant Denot Ricketts. Oh, that's my phone, y'all. I'm gonna have to get that. Y'all give me 1 second. All right, sorry about that. I usually turn my ring off, y'all. My bad. All right, so let's get into it. Against defendant Denot Ricketts arises entirely from Ricketts' alleged speech and conduct protected under Section 425.16 of California Code of Civil Procedure, which is commonly referred to as California's anti-SLAPP statute. The anti-SLAPP statute was enacted to mitigate the chilling effect of lawsuits directed against free speech and petitioning activities, and establishes a procedure followed by federal as well as state courts in California for prompt review and disposal of petitions arising from acts in furtherance of the person's right of petition or free speech under the United States or California Constitution in connection with a public issue. And as y'all can see there go California Procedure Code 425.16. As unintelligible as it is, it's clear from the allegations in Wiggins' PRO and attached exhibits A through D, his petition entirely focuses on 1. Random encounters with Ricketts at public events, 2. Social media posts, and 3. Ricketts' public challenge to a boxing match. Wiggins' PRO arises from activity expressly protected under the anti-SLAPP statute. First, Wiggins' PRO alleges that he and Ricketts crossed paths at Zeus Network events and while covering court cases. Wiggins has not and cannot provide evidence that from 2023 throughout 2025, Ricketts stalked him, harassed him, put him in reasonable fear for his safety, and or that Ricketts' behavior served no legitimate purpose. Wiggins' attempt to couch Ricketts' social media posts as evidence of a threat goes against public policy, competitive rivalry, freedom of speech, and the type of business both parties actively on engage in on a daily. Second, Wiggins has not and cannot claim Ricketts encountered him beyond events and places, whereas they both operate as new media reporters. This is protected activity that the anti-SLAPP statute seeks to protect. Finally, in order to be protected, the conduct or speech must be in connection with an issue of public interest. Case law defines matters of public interest as conduct that could directly affect a large number of people beyond the direct participants or a topic of widespread public interest. Wiggins' petition alleges that he saw Ricketts at Zeus Network events in multiple courthouses throughout America. Both parties have a remarkable history reporting on reality stars in celebrity court trials. Thus, Wiggins' PRO arises out of public conduct in connection with an issue of public interest and was thus protected activity, prong 1, under the anti-SLAPP statute, which is 425.16, subsidy E3. Because PRO seeks to prevent Ricketts from participating in public events, the burden is on Wiggins to show that he will prevail. Because Wiggins cannot meet this burden, for the reasons set forth in Ricketts' congruently filed motion to strike under California Civil Code of Procedure 435, Wiggins' PRO should follow suit with the request for temporary restraining orders and be denied. And then he gives a factual background. It says Wiggins has tracked Ricketts' social media account since April of 2023. His sole purpose was to recruit Ricketts as a new media proxy against his online enemies. Basically, Wiggins never invested in Ricketts' success. Ricketts sees Wiggins as a master manipulator, user, and liar. After several Instagram voice note exchanges, Ricketts told Wiggins that he could no longer control him. Ricketts then blocked him on Instagram, Twitter, and YouTube. Wiggins truly wishes for Ricketts to be his subordinate and validate his larger than life persona. Because Ricketts refused to do so, Wiggins weaponized his social media platforms against him. Ricketts has been entrapped in a defaming narrative, specifically labeling him as a stalker, weirdo, and obsessed loser. Wiggins is truly a hideous person on the inside and outside who prioritizes manipulating the internet instead of genuine human connection. In December of 2023, Ricketts saw Wiggins outside of a nightclub. He thought by being nice to Wiggins and allowing him to take photos he'd get back onto his platform and undo the damage he caused to his name and reputation. Around July the 8th of 2024, Ricketts grew impatient, then called Wiggins demanding that he publicly apologize for damaging his reputation. Wiggins refused to do so. Thereafter, there wasn't any private communications or encounters outside of seeing each other at courthouses throughout America. Okay, so now we got some tea. We got some tea, y'all. We got some tea, y'all. See, we got some tea. Okay, so now we're here to get into Zeus Network altercations. Early April 2023, Ricketts met Wiggins at a Zeus Network event. Wiggins in Bobby Lights, Zeus Network personality was doing, oh, y'all see that? He said that they were doing drugs inside the restroom, even offered Ricketts some. Next day, Ricketts reported this to his subscribers. Jonathan Wright, Zeus Network personality, informed Ricketts to watch his back, claiming Wiggins threatened to beat you up the next time he saw Ricketts. In July 2023, whereas Wiggins assaulted Ricketts by aggressively putting his hand in his face, Ricketts confronted Wiggins and both were removed from Zeus Network event. On September the 21st of 2023, Wiggins told more than 100,000 plus people that Ricketts is a stalker who attacked him for no reason. While at the Sean Diddy Combs trial, Wiggins confirmed his threat to be true. Many new media creators have referred to Ricketts as Armon Wiggins' stalker, racking up hundreds and thousands of monetized watch hours and donations at his expense on YouTube. And then he says the Diddy trial. During the Sean Diddy Combs trial, Wiggins went around the federal court, ruining Ricketts' name, likeness, and reputation even before he arrived. Ricketts didn't speak out against him directly because Wiggins already painted him a stalker who attacked him. There were no problems in minimum communication between Wiggins and Ricketts at the actual Diddy trial. Okay, so then he gets into Little Nas X. Ricketts attended a Little Nas X court hearing and Wiggins happened to be there as well. There was no communication. Later, Wiggins would get onto his platform and without saying Ricketts' name, called him a stalker, weirdo, and obsessed loser. Everyone knew he was talking about Ricketts. Then he gets into Megan Thee Stallion. Since July of 2025, Ricketts publicly announced several times that he would be attending Megan Pete versus Milagro Elizabeth Cooper's trial in Miami, Florida on the first day. Ricketts was the only YouTuber covering the case. On this same day, Wiggins created a video begging his audience for emergency funds to attend the civil trial in Miami, Florida. Within that same video, Wiggins continued to refer to Ricketts as a stalker, weirdo, and obsessed loser. Wiggins arrived in Miami, Florida, and immediately began interjection per toxicity around Ricketts' name, likeness, and reputation. Wiggins followed Ricketts and began antagonizing him. Wiggins essentially continued his harassing campaign against Ricketts, calling him a stalker, weirdo, and obsessed loser to anyone who would listen. Wiggins informed his audience that he planned to leave Miami prior to the trial concluded, but had a meltdown on Twitter while 3,000 feet in the air, defaming Ricketts consistent with his original defamatory statements made on September the 21st of 2023. Then he gets into the legal standards. The anti-SLAPP motions may be filed challenging petitions for injunction relief brought under Section 527.6 because they constitute cause of action under the anti-SLAPP law, and there is nothing in Section 425.16 which would exempt such petitions from the broad reach of this remedial statute. And then, as y'all see, there's a subquote from another court case. Under the statute, the court makes a two-step determination. First, the court decides whether the defendant has made a threshold showing that the challenge cause of action is one arising from protected activity, which is 425.16. A defendant meets this burden by demonstrating that the act underlying the plaintiff's cause fits one of the categories spelled out in Section 425.16 subdivision. If the court finds that such a showing has been made, it must then determine whether the plaintiff has demonstrated a probability of prevailing on this claim. And then there's a subquote from another court case there. Okay, so then it says, in conclusion, based on the foregoing, Wiggins PRO seeks to use this honorable court as an axe, shield, and sword to eliminate Ricketts as a righteous competitor and a rising business as a new media reporter. And then this is just a declaration. Oh, y'all, child, y'all see what y'all just pause your screen and y'all can see what he said there. Lord have mercy. Lord have mercy. And then, oh, child. So this looks to appear to be uh, a photo album. If y'all look at that top right, this is like the Knot's phone. So this is his library of his phone. Oh yeah, so it looks like 5 pictures. Y'all see that? Lord have mercy. Now I'm scared to scroll down. Hold on, y'all. Let me just put myself back on her. Let me make sure there is no personal. Yep, there's personal information. So I'm just going to scroll past that part. I may have read this part already. Oh, okay. So he filed. Oh, let me put y'all back on the screen. So it looks like the Knot filed a cease and desist notification. Notice to. Ooh, y'all see that? Y'all see that? There's some tea, y'all. There's some tea. I don't know. It says, come now before the court is defendant's motion to strike plaintiff's request for permanent restraining order is hereby granted. There it says it is but there's no date or no one signed this. So I don't know what this is. If this has been granted or not. It doesn't show the date. It doesn't show a judge name or anything like that. Again, when I tried to go pull these court documents, it showed that it was unavailable. So we'll just have to wait and see and go from there. But I'm going to go down here because this was also attached. It shows that this is a notice, defendant cease and desist notification. So let's get into this one. Please take notice pursuant to California. Y'all give me 1 second. I got a burp. All right, excuse me. To California Code of Civil Procedure 998. Denot Ricketts hereby demands plaintiff to publicly retract defamatory statements made and propagandized since September the 21st of 2023. Defamatory statements, hateful competition, and emotional distress is I don't even know how you say that word. Y'all give me 1 second. Okay, so that word is juxtaposed against plaintiff's petition. Factual background, Armon Wiggins has built a combined social media audience on YouTube, Twitch, TikTok, and Instagram of more than 600,000 followers in the past 10 years. Defendant has been a new media reporter for the last 3 years with notoriety for covering several high-profile criminal and civil cases involving celebrities. On September the 21st of 2023, plaintiff created a video ultimately painting defendant as a crazy stalker. Plaintiff has continued to aid and abet such defamatory statements scattered throughout his content for years. Such statements has interfered with my work as a new media report as well as my mental health. Since July of 2025, defendant publicly stated that he would be attending a celebrity trial in Miami, Florida on October the 15th of 2025. Plaintiff created a video stating he would not be attending that celebrity trial, and if so, he was going to fight the defendant. Defendant arrived at the celebrity trial on November the 15th of 2025. After defendant's review on the same day, plaintiff created a video begging his supporters for money to attend the celebrity trial. Plaintiff arrived on November the 16th of 2025. Same day, plaintiff lied to federal officers claiming that I threatened to attack him and only attended the celebrity trial to stalk him. Thereafterwards, plaintiff continued to antagonize defendant until his last day. In his November the 24th of 2025 YouTube broadcast, he stated he'd be leaving Miami, Florida on Tuesday for Thanksgiving holiday. Next day, Tuesday, November the 25th of 2025, while on a good job. While on a Spirit Airlines flight back to Los Angeles, the plaintiff continued defaming defendant by claiming he left the celebrity trial early because he's afraid for his life, considering his initial defamatory statement that defendant is a crazy stalker. Therefore, defendant hereby demands plaintiff use his at Armon Wiggins YouTube channel as well as his at ArmonWigginsX.com account to retract any and all statements arising from his defamatory statement made in a September the 21st of 2023 YouTube broadcast and agree to ignore, never speak on, or publish any defamatory statements about defendant. Potential consequences. Okay, so let's get it. Oh. Child. So defendant reserves all rights to hire an attorney in this matter. Defendant reserves the right to sue plaintiff for 1, defamation, 2, tortious interference with prospective economic I'm getting tongue tied, advantages and emotional distress in the amount of $25,000. Do y'all see that? $25,000. Any plaintiff bear all costs associated with this case and any other litigation that may arise from between the two parties. And this was filed on December the 5th of 2025. And I think, now let me take this off because I think this have personal information on it. Yes, it does. So I'm going to scroll past this page. Okay, so let me bring y'all back on the screen. Okay, so it says, is a temporary restraining order in effect? No. Why does this court date need to be rescheduled? It says, I am the restrained party, and this is my first request to reschedule the court date. The reason? Defendant has filed a special motion to strike anti-SLAPP and a motion to strike CCP 435. The plaintiff needs time to respond. Additionally, defendant needs time to consult with an attorney, nor is he fully available on 12/18/2025. Defendant is available between January the 5th and January the 16th of 2026. Defendant has prior engagements, tentative plans to be out of the state and out of the country between January the 20th of 2026 and throughout February the 28th of 2026. If this honorable court denied defendant motions, then he's available for bench trial between January the 5th and January the 16th of 2026 or thereafter, February the 28th of 2026. And as y'all can see there, that is the end of this form. Now, I will wait and see if this goes on the docket. So, disclaimer, this was given to me by Donat himself. And these pages are unavailable to actually pull, but he had given them to me. So just to let y'all know. Now, what are your thoughts? Because I do see comments coming through already. I had made part 1, part 2. This is part 3. What are your thoughts? What are your thoughts? Now, this is going to be an interesting case. As y'all can see, Armon has put out his petition for restraining order. Donat has come back and rebutted and also put out to strike and anti-SLAPP. So this is going to get interesting. Now, if there is to be a court case on the 18th, it looks like it may not be. It may not be until next year. However it goes, I will make sure I stay tuned and watch this particular case. Now, if you like what you see here, like, share, subscribe. I do appreciate y'all. I am now past 1,000 subscribers. So thank y'all so much. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I'll talk to y'all next time. Take care.